The Federal Employers Liability Act, which allows injured railroad employees to sue their employer for on-duty injuries, has a 3-year statute of limitations, which means any claims under the Act need to be settled or appropriately filed in a court of competent jurisdiction prior to the 3-year anniversary of the injury. Traumatic injuries are simple to assess for statute of limitation purposes. It begins to run when the injury occurs. However, in cases of occupational diseases such as asbestosis or carpal tunnel syndrome, courts have held that the statute of limitations begins to run when the injured employee knows or should know of his injury and its relationship to his employment. Obviously, when a physician tells an employee he suffers from an occupational disease, the statute of limitations begins to run. However, courts have also held an injured employee has a duty to reasonably investigate his condition or illness. Therefore, courts may find such a statute of limitations begins to run during the course of medical care for the injury. It is best to discuss concerns about a work-related condition with a doctor, give the doctor a complete history of the exposure to the suspected causes of the condition, and let the doctor assess whether there is a relationship to the job. If so, the statute of limitations begins to run at that time. If not, you'll have an explanation for any delay in pursuing a case if you learn after subsequent tests or examinations that the workplace did cause or contribute to the condition.